As a pretermitted spouse or child, you may have legal rights to an estate inheritance. Here are the basics so you can get started. A pretermitted heir is a person who became an heir after a will or trust was created. A pretermitted spouse is a spouse who married the decedent after the will or trust was created. And a pretermitted child is a child born to the decedent after the will or trust was created. Here's an example. Mary creates a will and trust outlining her wishes after her death, including distributions to her 3 children. A year after creating the will and trust, Mary has another child, yet she does not update her estate plan. Years later, when she passes away, her family discovers she never added her youngest child. That child would be considered pretermitted. A pretermitted spouse or child will take their intestate share, which is determined by statute. It depends on how many children of the decedent there are, etc. So it's a very simple formula to determine. You just need some facts to be able to do that calculation. A motion to pretermit refers to the legal action involved in asking a court to determine whether a spouse or child is a pretermitted heir. The process should be handled in consultation with a probate lawyer retained by or on behalf of the individual claiming to have been pretermitted. In this context, the terms pretermitted child and omitted child are used interchangeably. They're essentially the same. But there's a big difference between the terms pretermitted and disinherited. A disinherited child or spouse is a person who would typically have rights to take under an estate, a right to inherit, yet the decedent specifically stated in a will or trust that they wanted to exclude that individual. This is generally expressly stated in a will or trust, in writing. In many cases, a disinherited spouse or child may still be able to pursue legitimate legal claims to seek a share of their inheritance through litigation. This option should be discussed with an experienced probate litigation attorney. In many cases, it's clear a child or spouse is pretermitted. In other situations, it must be proven that a child is, in fact, the decedent's child and that the decedent was unaware the child existed or was alive. In any case, it makes sense for an individual to contact a probate litigation attorney to discuss their simplest, fastest, efficient, and cost-effective course of action. It helps to work with a probate lawyer or attorney near you. However, it's more important to choose an attorney who has experience working with the probate court in the decedent's county of residence. For example, if the decedent passed away while living in Los Angeles, it's likely going to be most effective to retain a probate litigation attorney familiar with the Los Angeles Superior Court Probate Division. At RMO Lawyers, we help people like you every day, so call anytime. We're happy to offer you a free consultation. Email us at hello@rmolawyers.com. Thanks for watching.